The full scope of harassment in the workplace beyond its physical and sexual manifestations, which has only started to be explored in recent years. In the past, abusive language was used, but the actions, especially when women were the victims, often went unpunished. Now that the official harassment code has been modified and put in place, the labor laws are catching up in several countries, including South Africa. And to unpack this further, I'm joined by Phetheni Nkuna from the leading law firm, Clive Decker Hofmeyer. Phetheni, thank you so much for your time. Just looking at the amendments of the law and how much more there has been protection for women, especially when it comes to sexual harassment in the workplace.
Good afternoon, and thank you for having me. So just to place the code, it's not necessarily new anymore. It came into effect in March of 2022, so that was last year. What the code has done is give a much wider definition of harassment. The previous code that we had was solely focused, or mainly focused rather, on sexual harassment. But the current code has actually expanded the definition of harassment, and it now includes things such as verbal bullying. It includes things such as demoting somebody without justification, abusing disciplinary processes. It also includes things such as cyberbullying, which is a form of online harassment. It also covers acts such as passive aggression, which could be negative gossip. It could also be things such as condescending eye contact, or even invisible treatment, something that you can't really pinpoint, but it is a form of harassment. So we do welcome the changes. We do welcome the introduction of this particular code, because it gives employees and employers as well clarity and guidance on what type of conduct would constitute harassment, which under the Employment Equity Act is actually a form of unfair discrimination.
Yeah, but looking at the grievance process, let's say in a workplace environment, if you're already a victim of harassment, the likelihood is that you may be seen to be either not entitled, but that you are not objective when it comes to the issues that may be before you. Is there also a danger that we need to be careful of, so that so-called victims understand that in the work environment there are different team dynamics, that if somebody gave you a snide look, or they didn't greet you when you said hello at the water cooler, that doesn't necessarily mean they are being, avoiding you, or any other harassment, if that's even an example.
Conduct needs to be looked at objectively. So like you said, the code describes something as constant negative judgment within the context of the workplace. And that becomes a bit of a challenge when you speak about the manager-subordinate relationship, where I have a right as your manager to give you feedback on your performance, to give you feedback on your output, which may not necessarily be a form of harassment. It's expected, it's normal in the course of the employment relationship. However, there is conduct that goes beyond what is normal or what is acceptable, and it impairs somebody's dignity. It causes the work environment to be hostile. It even goes as far as, in certain instances, affecting a person's mental well-being. So all of those need to be considered objectively, which is where the code comes in very handy, because it imposes, like the Employment Equity Act has in fact done, it imposes a duty on employers to have proper policies and procedures in place, and to communicate these so that people understand what constitutes harassment, how is it going to be dealt with, what is the process or procedure of reporting, and how will an employer deal with it, the investigation, the elimination part of it, which may necessitate disciplinary action against the perpetrator. perpetrator.
And as you were saying, in terms of the processes and ensuring that both sides are fairly represented and the issues ventilated to a point where there is an amicable resolution, is that it has to start with the employer. If an employee brings a complaint that my manager, for example, might speak down to me, I feel belittled, or he's using derogatory terms, I feel devalued, etc., that the HR process would then kick in, if I'm understanding you, failing which, then what is the recourse for the employee?
Certainly. So within the workplace, the employer has an obligation as soon as it becomes aware that there's been a breach of the Employment Equity Act through somebody perpetrating a form of harassment, whatever the type of conduct is, immediately consult the relevant parties. So this would be the investigative process. If the allegations are found to be credible, to take the necessary action, which I mentioned too, may be a disciplinary process, which may result, depending on the type of harassment, result in a warning or even somebody actually losing their jobs. Now, the code also spells out or points to certain different other forms of legislation that we currently have in South Africa, which protect people from harassment. The guarantees the right to equality. It also guarantees the right to fair labor practices. We've got the Employment Equity Act, which I've already spoken about. We also have the Promotion of Equality and Prevention of Unfair Discrimination Act, which really focuses on harassment as it would play out in general society. However, this piece of legislation may in certain instances find application within the employment context. For example, where an employee services members of the public and becomes victim of harassment, either through a client, through a contractor, etc. The other way around can also take place, where your employee actually harasses a member of the public. Then we also have the Occupational Health and Safety Act, which deals with employers' obligations to ensure a safe and healthy working environment and to take appropriate measures to protect employees. Of the Protected Disclosures Act, which principally protects whistleblowers against harassment, as well as being subjected to occupational detriment in the event that you are harassed. And harassed, like I said, takes different forms. You are entitled to be protected against occupational detriment. We then also have the Protection from Harassment Act, under which an employee can actually obtain a protection order against the perpetrator. So in addition to the Employment Equity Act, fortunately in South Africa, we have multiple other statutes that protect the right to not be harassed or subjected to discrimination.
And I just want to look at the relationship, maybe the dynamics more so between colleagues as opposed to subordinate and your line manager, whether the same principles can apply. I guess you would have to report that particular individual. If you weren't able to mitigate the issues around the office or the politics of the office yourselves, you then do the same process. But I think what is encouraging is that the evolution of the working space has become more inclusive and much more supportive, you know, in that happy employees, happy clients, and we all thrive in that regard. Phetheni.
Certainly. There are also reported benefits of how that can actually improve productivity. So like I said, if it does happen that it's your peer-to-peer type of harassment, you still have the right to report it to your line manager or to whoever the employer may have designated as a person responsible for addressing this type of complaints. Now, again, it is important for employers to deal with grievances or complaints of harassment. If they do not, in fact, we've seen this coming out of our courts, where employers who failed to deal with these complaints either deal with them appropriately or efficiently, or to even deal with them at all, have actually been held vicariously liable for the conduct of the perpetrator. So this is a warning to employers. If you fail to act as you should in law, you will be held liable.
All right, we're going to have to leave it there. Really appreciate your time. We're speaking to Director and Executive Management from a leading law firm, Clive Decker Hofmeyer, Phetheni Nkuna, talking about the amendments to the bill when it comes to harassment in the workspace. And now, as we alluded to earlier